Hi, good afternoon, everyone. Thank you for joining us today for our Ask the Expert series, Legal and Financial Planning for Alzheimer's Disease, featuring Michael Greenberg. So today we will begin our program. I do want to remind everyone that this session is being recorded. We are recording this session. So if you have any questions, please feel free to add them to the chat. My colleague Roni Kersey is here joining us today and will answer and monitor the chat questions, and we'll have a few for Michael at the end. So again, any questions that you do have, please share at via the chat. So we're going to keep going. So very briefly, we know that Alzheimer's is a disease that impacts our communities. We wanted to share a couple of facts and figures before we pass the presentation over to Michael. So again, Alzheimer's is a disease that we're seeing increase. Currently, we have 11 million individuals who provide unpaid care to their loved one living with Alzheimer's and other types of dementia. We know that there are currently 6.8 million, close to 7 million individuals living with Alzheimer's disease, and we are expecting that figure to increase in the upcoming decades. We know that Alzheimer's disproportionately impacts our Black and Latino communities, and it disproportionately impacts women. We are committed to providing care and support to our community. Anyone who is navigating this disease, we're here to, again, provide that support to you. Our mission is to lead the way to end Alzheimer's and other types of dementia. We do this through community outreach. We do this through education. We do this through providing a community for both caregivers and those that are seeking to find that are diagnosed or are seeking to get a diagnosis. So just very briefly, we wanted to really ground our work and share the differences between dementia and Alzheimer's. So dementia is a collection of symptoms related to cognitive decline. Alzheimer's is a specific disease. So again, dementia is just the general word that we use to describe these symptoms related to cognitive decline. That includes changes in behavior, changes in the way a person verbally communicates. Alzheimer's is a specific disease that falls under that dementia umbrella. Very briefly, we are here to provide 24/7 support to you. We have our 24/7 helpline. The number is 800-272-3900. We have professionals who are available to guide you in whatever support that you may need. I do always like to just a quick point of clarification. Our helpline is a starting point for folks. It's a great way to learn a little bit more, get information, know that you can reach out to us multiple times. I always think it's important to clarify that the association, we don't do case management, but we are here to be a sounding board, to provide referrals, to connect you with resources in your community. We offer free educational programs such as this program today, the special program today. We have support groups that are available for our community virtually and in person. We have support groups for caregiver as well as individuals in the early stage of their diagnosis. And before I introduce our guest speaker, I do want to invite everyone to our in-person program that we are having. We are having Dasha Keeper, who will lead a special in-person program in our office. So we're across the street from Grand Central next Wednesday, November 6th from 1 to 2 p.m. The program is called Your Brain on Caregiving. So we're going to discuss the cognitive and emotional challenges a caregiver might face and navigate. So we really encourage you. We hope to see some of your faces here. If you are based in New York City, I know we have a couple folks tuning in from out of state. So I'll make sure to send this information via email at the end of our program. So I'd like to now introduce our very esteemed guest speaker, Michael Greenberg. So, known as the attorney with an astute, compassionate, and patient approach, Michael J. Greenberg treats all clients and their wishes with uncompromising respect. Before starting his own law firm, Michael spent nearly a decade working at several prestigious law firms. Michael entered estate planning and elder law after his father was diagnosed with early onset Alzheimer's disease. He has firsthand experience with many of the issues that his clients face today. Michael is admitted to practice law in New York, New Jersey, Connecticut, and Florida. Michael has been named a rising star in estate planning and probate in the Metro edition of the New York Super Lawyers each year since 2017. And New York State recently certified his firm to provide continuing education to licensed social workers. We're also very fortunate that Michael serves as the chair of the legal committee of the New York City chapter of the Alzheimer's Association. Michael, we're extremely grateful for your continued support, and I'm going to go ahead and pass it on over to you.
Thank you so much. Appreciate being here. It's always an honor speaking to so many people that the association has touched and people have reached out to the association. I think we're going to take questions, but I'll answer them at the end. So I think we'll have a space for people to ask. I promise I'll get to all of them at the end, but just to keep things going, I think I'll go through the presentation first. So let me put through the first slide. Jackie, can you put on the slide? I don't see the slideshow.
Oh, yes, of course. Let me go ahead and pull that up for us. My apologies. Thank you, everyone, for your patience. My apologies for the technical difficulties on my end. Thank you, everyone. Again, my apologies.
All right. Let's go through. Jackie, can I skip the slides or are you doing it?
Yes.
All right, let's skip to the next one, next one, next one, next one. All right, so let's go through first what is elder law. So a lot of people have heard of betrusted estates and litigation, other things like that, but what exactly is elder law? It's the practice of working with individuals and their families to, one, preserve dignity and choice of decision making. We want to make sure that just because someone has been diagnosed with something, diagnosed with Alzheimer's, diagnosed with dementia, doesn't mean their life's over. Right? It doesn't mean that they don't have the right to make decisions for themselves in terms of where they'll live, who will take care of them, who is going to make decisions for them on their behalf, if and when they're unable to. So this elder law goes a lot through that. Protecting assets. So a lot of what number one payer of long-term care in New York and around the country is Medicaid. And as part of the Medicaid process, to qualify for Medicaid to pay for their care, it's care at home or secure nursing home, is qualifying for Medicaid by using trusts and other sort of tools to use to protect assets, because people have worked a lot their lives and they have accumulated assets, right? Whether it's a house, annuities, life insurance, brokerage accounts, 401ks, things like that. We want to make sure just because they have to pay for care that could be tens of thousands a month doesn't mean it'll wipe out their nest egg they've worked hard for. So a lot of what we do is protect assets so they qualify for the care they need, but make sure that assets are protected for their loved ones. Provide guidance on housing, insurance, legal documents, right? Planning for long-term care. So long-term care is a pretty comprehensive umbrella. It encompasses the protecting assets portion, where someone's going to live, how they're going to live, who's going to make decisions for them, the doctors they'll see, who's going to pay for that care, who's going to pay for the doctors. So that's what I call sort of a long-term care plan. and to coordinate with professionals such as care managers, financial planners, long-term care insurance planners, etc. So as they talk about, oftentimes raising a child, that takes a village to help with someone with Alzheimer's dementia. It takes a team. So it takes the lawyer, the social worker, the urgent care manager, the accountant, financial planner, the children, the loved ones. They all sort of have to be on the same page in order for any plan to put into place to help the loved one with Alzheimer's dementia really be able to, in order for the plan to work properly, the long-term care plan, the elder law plan, sort of everyone has to be on board and understand what's going on. Next slide. So first we'll go through advanced directives, what they are and what each one is and what they can do for you. Go through long-term care, go through a little bit through Medicaid planning, and then we'll talk about trust for asset protection purposes. So first, documents of power of attorney. So power of attorney allows someone to appoint another person to act on their behalf or to make financial decisions, right? To handle their bank accounts, real estate, create trust on their behalf, apply for Medicaid, change beneficiaries on different sorts of accounts, annuities, life insurance. So it's whatever you can do on your own, this person you appoint as the power of attorney can also do on your behalf. It's very broad authority, so be very careful who you appoint. So just because you have 2 children doesn't mean you should automatically just appoint those 2 children, right? One might have other drug issues, legal issues, trouble with handling money, and one might be very good at that, very good at handling money, being very trustworthy. And that's the person you want to appoint, the trustworthy one. So it's not about who you love, it's about who you leave assets to in a will or in some other way to leave money to someone upon death. This is just who's going to make decisions for you and act on your behalf while you're alive. And make sure to appoint successor agents. A lot of my clients are in their 80s and 90s, and all their friends are in their 80s and 90s. So you also want to make sure that you appoint someone, the first person you appoint is not able to act, then you're able to appoint a successor that maybe perhaps a little bit younger, so that they're more likely to be able to step forward and step into your shoes to handle your finances for you. Next
Michael,
slide.
I just want to let you know, we just got a request through the chat that maybe you could speak a little slower. I know you have so much wonderful information you want to get across today. I think some people are finding it's going by a little quickly.
Sure.
So I just wanted to give you that feedback. Thank you so much.
We want to make sure the power of attorney you have is durable. A non-durable power of attorney just means it lasts until you become capacitated. The durable means it lasts through incapacity. So any power of attorney you do, you want to make sure it's durable. It's portable state to state. That being said, if you spend a significant amount of time in another state, you should probably have documents in that state as well. So a lot of my clients are snowbirds. They go between the tri-state area, New York, New Jersey, Connecticut, and Florida. So we'll do documents for their home state or the state they're close to the tri-state area state, let's say New York. But we'll also do documents in Florida as well. The reason being is that if you're let's say, put into an institution in Florida and you need to access money, you don't want to necessarily give them a New York power of attorney to a Florida bank. They may not be used to it. They may not have seen it before, and you want to make sure things go smoothly. So we often suggest that people get documents in whatever state they spend a significant amount of time in. You can make transfers right away. So as soon as the principal, the person who creates the power of attorney, signs, and as soon as the agent signs, it's effective. It will not expire until principal designates. So principal is just another word for person who creates the document. So you want to make sure, let's say you did a power of attorney 30 years ago, and you appointed your Aunt Bob or Uncle Bob as power of attorney. Now Uncle Bob has, I don't know, drug issues, money issues. You want to make sure that any place that you gave that old power of attorney to, you got to give the new one to, where they name someone who's not Uncle Bob, or specifically retract that power of attorney so that Uncle Bob can't go in and manage and perhaps steal your money or do things that are against your interest. Next slide. Right, there are 2 parts: the power of attorney. Next, you recently got rid of the statutory power of attorney. But the mental capacity, I think, is pretty important here. It requires awareness and understanding what you're doing. Right? Do you know who you are? Do you know who you're appointing? And do you know what your assets are? So it's not that high of a threshold. So just because you've been diagnosed with Alzheimer's dementia does not mean you're no longer able to do anything. You're no longer able to sign documents, create a new power of attorney, healthcare proxy, a will, or trust. So that's why oftentimes a client will call me and say, hey, I need a guardianship for my loved one. So I'll say, because they recently been diagnosed with Alzheimer's, so I'll say, well, not necessarily. Let me meet with them. Let me see what the capabilities are. Let's see if they understand. who they are, who they're appointing, and what's going on. And then based on my own sort of analysis, I can determine whether or not they have the capacity required to do these sorts of documents we're talking about today. Next document is a healthcare proxy. This is a document where you can appoint another person to speak for you to help make healthcare decisions. As long as a person is able to speak for him or herself, then they'll be able to speak, they'll be able to make all of their healthcare decisions. This is only in the instance where the person is no longer able to do so. Like the power of attorney, it's binding on all healthcare proxy, all healthcare institutions, and it's portable, state to state. And then that being said, I would get these documents done in another state if you spend a significant amount of time in that state. It's very flexible. So basically, all this document does is say, I allow this person to speak for me. I give them HIPAA authorization. HIPAA are sort of the privacy health laws. I give them HIPAA authorization to speak to my doctors, to access my medical records, so that they can make an informed, intelligent decision about the healthcare for the individual. Should not be a quick decision, right? You should think about who would be the best person for this. Again, just because someone is your child doesn't mean they're necessarily the right person to make the decision for you. It could be a friend, it could be a sibling. And should take into consideration the relationship and should be discussed, right? You don't want to surprise somebody by saying, by someone getting called like one day saying, hey, your Aunt Sue named you as agent of power of attorney, you do make life and death decisions. This is something that you should talk to the person you appoint, see if they want to do it, see if they agree with what your wishes would be. Because what you don't want to happen is someone turn down the responsibility, and then there's no one left to make those decisions. Then you'd be forced to do a guardianship. So it's really important that you have these documents in place, that the people you appoint understand their roles and accept it. Living will, this is sort of what people call a pull the plug document. It's a legal document in which a person states their wishes if they're in a terminal or incurable decision. They say things like they want a resuscitation, they want CPR, they want feeding tubes, forced liquids, things like that. Or we might either don't want all of those, or you want all of those. So it's really up. It's up to the individual. It's a document for the individual to the healthcare institution about what they would want in that sort of instance where they're at the end of their lives. So what happens if you don't have these documents? Well, basically, the government will appoint someone to make those decisions for you. They'll appoint someone to make financial decisions. They'll appoint someone to make healthcare decisions. And the person may not be the spouse or the children, especially if the spouse or children or others are fighting over who gets to have that role, who gets to make those determinations. So a judge will have to determine if the person has capacity or not. Determine who would be the most appropriate person to make healthcare decisions or financial decisions. It doesn't have to be the same person. And oftentimes there are lots of lawyers involved, right? Each person applying for guardianship could have a lawyer. The judge appoints a lawyer to represent the interests of the incapacitated individual. And oftentimes it's a long, time-intensive, expensive process. So that's why it's so important to have these documents in place so that you could avoid having to deal with a guardianship proceeding. Right? There's a guardianship of the person. That's when a court appoints a decision maker for making healthcare decisions. And a guardian for the property is who appoints a person who makes financial decisions for the individual. Guardianship tasks, right? They manage assets, debts. Basically, they take over your life as you to make all financial decisions, right? You pay your taxes, pay your bills, arrange to go to doctors and things like that. That's what this person will do. The guardian will do. All right, part two. All right, let's talk about Medicare. A lot of people say, well, what do I need to worry about Medicaid? What do I need to worry about long-term care? I have Medicare, which is this great program that I paid into for all these years when I was working, and that'll pay for everything. Unfortunately, it does not. It'll pay for up to 100 days in a hospital-like setting, as a nursing home or rehab, but it's only if you're first go to a hospital, and then you're discharged directly from the hospital to the rehab center, but does not pay for long-term care in your house. It doesn't pay for long-term care at a facility. Only Medicaid does that. Right? It's quite expensive for long-term care costs. These numbers are a little old, but again, the assisted living, The high around $17,000 a month. There's some assisted livings in the city now that just opened up in the last few years that are up to, especially if you need, it's called memory unit care for people with Alzheimer's dementia. It's up to $21,000 a month for some of the more high-end ones. So it's really expensive to deal to deal with long-term care. Home care is around $7,000 a month. I think the high is around now about 11, 12,000 a month. A nursing home, the median I think is up to like 19,000 a month, 17,000 a month, and the high, is up to like 25, 30,000 a month, depending on what the care is. So it's really not one of those things that most people can sort of self-fund for. Most people don't expect to be in an assisted living or nursing home for that long, but unfortunately, people are spending a larger portion of their lives in these sorts of facilities. And that's why whether it's getting long-term care insurance, doing a plan to qualify for Medicaid is so important. So, because again, like it's tough to self-fund and to pay for this sort of long-term care. All right, let's talk about a little bit about Medicaid eligibility. Right, you need to be medically needy, United States resident, and means testing. Means testing is usually the one where people like ask the most questions and have the most issue with. So I have a lot of clients that say, Mr. Greenberg, there's no way I could qualify for Medicaid. I have too many assets. I make too much money in income, whether it's Social Security or pension. But when you actually go to speak to an elder law attorney and go through what's included, what's not included, it's not as hard as you'd think, right? So the number is $30,000 in the recipient's name, the person who applies for Medicaid. Doesn't sound like a lot, but it doesn't include a lot of things. It doesn't include any retirement plans, so IRAs, 401ks. It doesn't include anything in a trust. So you can put pretty much all your assets into a trust. It doesn't include life insurance. Most life insurance doesn't include what you pay for burial. So it's actually not that hard on paper to get below the $30,000 number. So that's assets, right? There are two things. The assets are things like your house, your 401k, your brokerage account, annuity. Those are sort of like your assets. And then there's your income. Income consists of things like a pension, the required minimum distributions from your IRAs, 401ks, your Social Security, and you're allowed, and the person who applies is allowed basically $1,600 a month. Which again doesn't sound like a lot, but you get to use what's called a pooled income trust to pay anything above that. So let's say you make $2,600 a month in Social Security, and your limit is $1,600. What you do is you put the overage, the $1,000 overage, into the pooled income trust, and you pay bills using that. And then, so that basically every month you put $1,000 in the pooled income trust, and that $1,000 can be used to pay anything that's in your name. You could pay your mortgage, you could pay your rent, your credit card bill, your Verizon bill, anything like that. So it's actually not that hard to qualify with the $16,000. But that's only for home care, right? We talked about two types of home care before. There's home care Medicaid, where New York State will pay licensed agencies to send caregivers to your house up to 24 hours a day, 7 days a week. That's home care Medicaid. Then there's institutional Medicaid, and that's the Medicaid where you're in a nursing home or rehab center. So the $1,600 a month and pooled income trust, that's only for home care. For institutional Medicaid, you're only allowed $50 a month. That's it. No pooled income trust, no other way to really save the money. So it's really, so most of my clients, they come to me saying, hey, I'd like to put my loved one onto Medicaid. I want to put in a nursing home. I say, well, it'll probably benefit your loved one and you, spouse or friend or child, to try to have the person home first. Try to keep them at home, keep them on home care Medicaid, because they could keep significantly more money and you'll be able to protect significantly more assets at home than you would be at a nursing home. Next slide. Right, let's talk about the pooled income trust. So it's set up by a non-for-profit institution. All the money that you make above $1,677 a month goes into this pooled income trust. They charge an initial fee, but it's usually pretty nominal. They get the money if there's anything remaining, right? So it's not an account you want to build up a balance in. So I usually tell my clients it's sort of a use it or lose it. So if you have $1,000 a month that goes in the pooled income trust, make sure you find $1,000 a month in different expenses in order to use it up. Because again, if there's any money left over, it does go to the not-for-profit. Right? I mentioned before two types of Medicaid and different types of look-back periods. So right now, there are two types of Medicaid: community care So it includes personal care, physical therapy, home health care, clinical outpatient services. That's all in the community, and that's great, and that's easier to qualify. And then there's institutional Medicaid, includes things like hospital, medical facilities, and nursing. Next slide. Right, so right now, for community care Medicaid is a 1-month look back period. So if you stuff all your, if you put your house, most of your assets into a trust here in, where are we? Yeah, we're barely in October, still October. November's almost here. So if you stuff your trust with all your assets here in October, you can qualify for community Medicaid as of November 1st. It's great. This is going to change. New York has been trying to change the look back period for years. Basically, when COVID hit, it was supposed to start around when COVID hit, and then pushing it back year after year after year. I think it actually will happen this time. They say sometime in 2025, there will be a 2.5-year look back period. So that's why a lot of my clients are doing this sort of plan now. They're creating the trust, they're transferring assets to the trust, they're doing that all now because once 2025 hits, if they try to apply for Medicaid then, they'll look back to see what all their assets were within 2.5 years of application. For institutional Medicaid, there's a 5-year look back period. So in any application, you have to send 5 years of every statement of every asset you have, all the properties you owned. It's a much more comprehensive application. It's much harder to qualify for institutional Medicaid than it is for community Medicaid. Next slide. Right, well spouse concerns. So a lot of people say, well, what do I need to worry about Medicaid if I have a spouse, right? My well spouse would just do what's called spousal refusal. And it sounds nice, right? Spouse just says, I refuse to pay. That being said, they can still go after the well spouse if they have above their own income and asset limits. So right now, the income limit is $3,700 per month for income for well spouse, and approximately $150,000 for in assets. So as part of any sort of Medicaid plan for a married couple, we always try to get their assets all below the 150 number and their income below the 3,700 number, so that Medicaid can't go back. So with spousal refusal, they'll say, okay, your loved one can qualify for Medicaid, but Medicaid can still go after the well spouse if they have above those income and asset levels. So it's a really comprehensive plan that we have to do to make sure someone can qualify for Medicaid. Right, so let's talk about Medicaid qualifying trusts. So this is the trust for people that have assets that want to qualify for Medicaid use in order to qualify. So they'll get below the $150,000 number for the well spouse, $30,000 for the applicant spouse, or just the applicant in general. This is what you use. So the person who applies, as well as their spouse, are usually the grantors, meaning they're the people that create the trust. They could have the children or other loved ones as the trustees. The grantor can't be a trustee of their own trust, and this trust is what's called irrevocable. So you can't put things in and out. It's not like a checking account. It's not like what's like a revocable trust. It's one of those things that it's really sort of try to think of it as a lockbox. So you put the assets in, but you can take the money out. You can take some of the money out. The only money you can take out would be the income. So things that are considered income are things like interest and dividends, or we consider what's income. Everything else is what's called principal. You can't take out. So think of the lockbox for the principal, but you can get out the income from it. There's a 5-year, so the look back period starts not when you create the trust, but when you fund the trust. So let's say they start the trust, usually on the same day you start the trust, you put the house in, that starts the 5-year look back period for that. But let's say 2 years before you apply, you put the annuity in. So let's say 7 years ago, you put the house in, 2 years ago, you put the annuity in. The house would be protected, but the annuity would not. And just because you put something in later, doesn't sort of taint what you've already put in there. So you don't need to worry about any of that. All right. And Medicaid is just better than gifting. So I have a lot of clients that say, well, what do I need to bother with a trust for? Why can't I just give everything to my kids? Right? That sounds nice, but there are a lot of issues with that. First is the tax issue. If you just gift an asset to somebody, you lose what's called a step up in tax basis for a depreciated asset. So let's say you bought your apartment 50 years ago for $100,000, and now it's worth $1.1 million. If you gift that asset to your child, when they sell it, they're going to pay capital gains, the difference between what you purchased it for, which is $100,000, versus what they sell it for, $1.1 million. So they're going to pay capital gains on $1 million. That could be hundreds of thousands of dollars. Instead, if you put in a trust, when the grantor dies, the beneficiary gets what's called a step-up tax basis. So they'll pay capital gains not on what it was when their parent purchased it, but what it was at their date of death. So let's say they sell the property within 9 months of when the person died, they're not going to pay any capital gains on it. So they could potentially save hundreds of thousands of dollars in taxes by putting it in trust as opposed to gifting it to a child. Right? Another issue is against outright transfers to children. Right? If you transfer a house to a person, they could evict their parents. It sounds crazy. It's probably not going to happen, but it can happen. Right? What if the child you transfer to gets married or divorced? That's now an asset in their name, and your future son or daughter-in-law can try to get their grubby hands on it. Right? What if they own their own business and get sued? That's an asset in their name. Or what if you need the money during the look-back period, right? There's a 5-year look-back period for nursing home. What if you gave your child $500,000 with the expectation that if they needed any money, the child would spend the money on their behalf? Well, they don't have to, right? Once you give the money to somebody, it's theirs, and they could do whatever they want with it. And also, they just may use their money responsibly, right? Let's say they have a drug issue, they have a gambling issue, they just may not be the appropriate person to use the money. Well, if it's in a trust, it'd be more protected. Right? The Medicaid Asset Protection Trust process, right? The first thing you do, hold on. The first thing you do is create the trust. Usually you have the grantors be the individual or the married couple, and you have trusted friends or children as trustees. You place the house, the majority of your funds in the trust, right? We're not trying to impoverish you day one. We want to make sure your assets are protected. But so you still leave some money outside the trust because you still have to live. It begins the 5-year look-back period. In the meantime, you have whatever your income is to pay for your lifestyle. And then upon the Medicaid application process, the person who applies has less than $30,000 number, and the house and the rest of the assets you put into the trust are protected. Right? Choosing a lawyer, not all lawyers are created equal. Right? Just because somebody went to law school doesn't mean they know this. They know how to create an asset protection trust or long-term care plan. So just because somebody did your house closing 30 years ago or representing you in a DUI case 10 years ago doesn't mean they'll be able to do this. It's a very sort of specific, specialized area of the law where you really want someone that really knows what they're doing to do this. Where to find somebody who does this? There's the National Association of Elder Law Attorneys, or NALA. There's the New York State Bar Association Elder Law section, so you can find a lawyer doing that, as well as any of the lawyers on the panel for the legal committee for the Alzheimer Association chapter. We're all very qualified to help you with this sort of plan and go through what makes sense for you and your family's situation. Right? You pay now or pay later. Right? If you have assets to protect, that cost of a lawyer is worth it. I have a lot of people that call me that really have no assets and they don't need me. And so they don't need to pay whatever my hourly rates are or whatever flat fee is. But it's only when you have assets, right? If you're I usually say if you're middle class or upper middle class, you have assets you want to protect for your children or loved ones, then it's worth it, right? But fee structure is different, right? Some lawyers charge for initial consultation, some do not. I don't charge for initial consultation, some lawyers do. Some lawyers charge an hourly rate, and some lawyers charge a project fee, depending on what the service is. So it's really one of those things you really need to talk to the attorney, and every attorney is different about how it is that they get paid for the services they provide. Right, different resources, right? National Association of Elder Law Attorney, the Alzheimer Association, legal aid. So if you ever need anything, there's different resources out there you could contact to find out what is best for you in your situation. Right? There's a checklist for meeting with your lawyer. You want to come in with as much information as possible for your attorney in order so they can have the best sort of picture as to what your situation is. So come with your statements, right? All your assets come with the deed, bank statements, pension, 401k, list of all your property, like what you own, how you own it. Do you own it with somebody else? Copies of your existing estate planning documents, if any. Tax returns are helpful. Life insurance policies, long-term care insurance policies. If you're looking to be admitted into an assisted living or a nursing home, Well, we often review those admission agreements, see if they make sense or let you know what they say. And also come with a list of names, addresses, telephone numbers for your team, who's going to be involved. So the accountant, the care manager, financial planner, children, other loved ones, whoever's going to be involved in sort of your long-term care plan, it's a good idea to be there to have them involved and give your attorney the list of names so that they understand who they need to work with. Right? Take care of yourself too. Like, take care of yourself being the loved one. So, I mean, a lot of these things depend upon somebody being alive, somebody being there, being healthy, to make sure that whether you're physically taking care of someone as a caregiver or you're handling their finances. So don't forget to take care of yourself, right? When my dad was sick with Alzheimer's, I was need to remind my mom, hey, Mom, don't skip your doctor appointments. You make sure you get a good night's sleep, go to the gym, eat healthy. Because if my mom wasn't around, it'd be much more difficult for me and my brother to basically handle my dad. I mean, I had my own family to take care of, my brother's own family to take care of, our own jobs, their own lives. So if my mom wasn't around, it would have been very difficult. So you want to make sure they take care of the caregiver because it's not uncommon for the caregiver to pass away before the person with Alzheimer's dementia does. All right. So yeah, I'm happy to stay and answer any questions anybody has. In the chat, I'll put my contact information. I'm happy to be a resource for anybody that needs one. Hold on. Yep. So I just put my. I don't know. Hold on. Let me put it in the public chat. See how it
Okay.
works.
I can do that if you'd like.
Yeah, if you could put it in the public chat, I appreciate
Yeah.
it.
Great. Michael, we did get one question that came through the chat during your presentation, and they were wondering when qualifying for Medicare, can you hear me?
Yeah, I hear you.
Um,
Yeah.
how much is for the burial allowance for that?
Well, for Medicare,
I'm not
there's no.
Medicaid for when you're qualifying for Medicaid.
Yeah, as long as you prepay and it's called an irrevocable contract, it doesn't really matter what it is, right? So you could be
Okay, so but it would
15.
have to be prepaid in order for it to.
Yes, it needs to be prepaid. It needs to be irrevocable. So, and also, I mean, the prices for everything, whether it's healthcare or burials, cemeteries, plots, they're going up. So, for a lot of people, an easy way to get down to below the $30,000 number is to prepay their funeral. And all funerals, whether it's elaborate or not, they're at least, I don't know, $8,000 to $9,000, even cheap ones. So, if you could prepay that, get that done, it's one of those things that you might as well do it if you can.
And it looks like we received another question in the chat. Let me see. This is a question from Ryan Michael. It says, if an asset like a house is in a trust and there is a spousal refusal and it's less than 5 years, is that asset at risk from Medicaid institutional care?
It is if the spouse predeceases, right? So, I mean, that happens, right? Because once the spouse passes away, then if it's, so that's why you really need to get through the 5 years if possible. I mean, there are different things we can do. There's sort of gift note programs and things we can do to protect assets. But especially if the spouse isn't alive, it's going to be a lot more difficult. But again, this is more complicated question. I mean, I'm happy to go through with somebody individually, but it's so the answer is there are things you can do, but if you don't get through the 5 years and there's no spouse, it's going to be very difficult too.
Thank you, Michael. We have another question from Tom. From people who have too many assets for Medicaid, are there financial planners who are knowledgeable about Alzheimer's?
Yes, and I don't know if there. I mean, maybe I should know this, but I don't know if there's an actual sort of certification for financial planners who are experienced dealing with people with dementia issues. I mean, I work with a lot of financial planners who are very good at this, who are experienced with people with Alzheimer's dementia. So I'm happy if someone wants to reach out to me for a financial advisor with experience in this. I'm happy to help and connect them. But I don't know if there's any sort of public list available out there for people to look at.
Thank you, Michael.
I did place a couple of links just so people know if they didn't see in the chat, of a couple of one organization where you can find a lawyer, one of the organizations that Michael mentioned. Put the link in the chat. There's also a link for, if you're looking for free or low cost legal services, if that's a concern, there's a link for that also in the chat. So Michael, I put in the link for the NAELA. I don't know if there's other links that maybe we could put in for people as well.
That's probably the best one. I
Okay.
mean, Nail is the way is a lot of people find me on Nail. I'm on Nail. I mean, it's a good resource. So no matter where you live, you want to find someone close by, you just put in your zip code, and I'll show people based on location, people nearby.
Okay. We do have another question that came through from Deanna. Wants to know, is a house not in the patient's name but in the spouse's name counted for Medicaid?
Yes. Unfortunately, married people, they're counted as a unit. So yes, so even though it's not in the patient's name, the applicant's name to Medicaid, you still need to come up with a plan to protect that house for the spouse, the well spouse, so that Medicaid doesn't go after the well spouse for payment for what they provided for the Medicaid services.
And Michael, I do a lot of care consultations here at the association. And something that's come up for me that I'm wondering about is, when does it make sense to maybe, instead of doing a trust to try to protect assets, to maybe just to do the spend down until you qualify for Medicaid? Who might that make sense for?
If you have like under $100,000 in assets, you probably just do the spend down, right? But the spend down, you got to buy things and pay for things that are for the loved one, right? You can't write a check to your child for $80,000.
Mhm.
It's one of those things. You're like that's why prepaying for a funeral is a good one. And that the funeral lobby in New York State is pretty strong, and they made this exception. But you could pay for your own funeral, your spouse's funeral, your child's funeral. So a lot of times, if you're on the cusp, like you have maybe $150,000, you could buy a funeral for you and yourself and all your family members, and get
Mhm.
below that $30,000 number.
Gotcha. Okay. And then what about for someone who maybe doesn't have any dependents, and is not looking, I, I guess the pool trust makes sense to protect your assets if you're wanting to reserve those assets for someone else. If you're on your own, maybe, does it still make sense to do a trust?
Look, if you're not looking to protect assets, like if it's your money and you don't care you're not looking to pass it on to someone after you die, then yeah, you probably don't need a sophisticated plan with trust and other things. Uh, but again, it's for people that want to protect assets, that want to make sure their spouse is protected, their children, or even charities. I have a lot of clients that they may not be married and not have children, but they have charities they really want to support.
Mm.
Instead of the money going to Medicaid, they wanted to go to this charity of choice, let's say the Alzheimer Association, that they would do this plan in order to protect the assets for the Alzheimer Association. So it's really depends on what the person wants to do and what their focus is for what's going to happen after they pass away.
Thank you. It looks like we have two more questions here. Ryan wants to know, is spousal refusal going away in New York?
Not that I've heard.
Let's see. Tom wants to know, is there some way to avoid Medicaid recovery where the city sues the caregiver spouse for care?
Yes, I mean that's the problem with when the well spouse has too much money, even with spousal refusal. So that's why the plan has to sort of encompass both the person who's the applicant as well as the well spouse, because they can go after the caregiver spouse, or not necessarily the caregiver spouse, but the well spouse.
I do see one here that it looks like it's a little involved. From Tanya, it seems to be very specific about their situation. I'm not
Yeah,
sure that.
that's something that's more for an individual to ask me a consultation.
Yeah, and also, just for Tanya and for anyone else here too, you can reach out to the Alzheimer's Association. You can reach out through our 800 number. That's 800-272-3900, and you can receive a care consultation. there. You can also ask them to refer you to the local chapter if there are things that are specific to New York that you wonder about, and they can refer you to us, and we can follow up as a care consultation, and we can put you in touch with Michael. And we also have referral, we have a referral list for elder law attorneys in the area as well. So, things that are kind of very specific and maybe a little involved. Where we're here, you could reach out to us and we can kind of spend some time one-on-one to better understand your situation, and then from there, better connect you to the information and the resources that you need for moving forward. And I'm so sorry to hear, I know that these things can be very difficult, and it seems, Tanya, that you've been going through a difficult time. We're here to support you emotionally and practically, and that goes for anyone else as well.
Michael, I received a private chat question. It reads, are there benefits available specifically for veterans needing long-term care? For veterans, should veterans look for an elder law attorney that has experience working with veteran benefits?
There are some, they're not in New York State, they're not that much, there's not that many. I mean, I'm not a specialist in veterans and veterans affairs. I know a couple people who are, so if someone wants to email me, I'll refer you to an attorney who is more specialized in that. Uh, but yeah, I know there are some, there are some benefits, but I don't think they're that many. It's not that much.
Okay, thank you.
Going to put whoever asked that question, I'm looking it up now. I'm going to put a link in the chat for you. What I do recommend for people who are veterans is start by reaching out directly to the Veterans Administration, to a social worker there. They do have very comprehensive long-term care planning. And so they will go through, and depending on if it was active service, not those kinds of things, they will assess exactly what it is that you're eligible for from the VA, and they will help you navigate all of that. So I think that that's a good place to start. So I'm looking that link up now, and I'll get that into the chat.
Thank you. I received another question. I don't think, or we have a couple of questions. So another, Milton, yes, the question is, will recording of this webinar be available later? We will have this recording on our YouTube page under our Ask the Expert series. So rest assured you'll have that. And I do want to remind folks that I will be sending out the links that we have shared in the chat, as well as additional resources via email. Debbie asked a question, Michael, should a person's legal capacity be evaluated upon a diagnosis of Alzheimer's?
Maybe. That's not a straightforward question. I mean, you don't want something on record saying that, oh, this person doesn't. I think it's one of those things that if you meet with an attorney, that the attorney would decide for him or herself if the person with the diagnosis has capacity. But yeah, I don't think you want to go have something in writing to say this person does, or especially the person does not, and you later deciding you want to do a legal plan. So I don't think that's the first thing you should be doing. I think the first thing you should be doing is obviously making sure the care plan's in place, but then meeting with an attorney to sort of assess whether the attorney thinks the person has capacity to do a legal plan.
Thank you, Michael. Do we have any other questions?
So Jackie, I was not paying
we will
attention.
have this recorded. We will have this recorded for folks.
I'm sorry. So I was looking up some information. I'm not sure. Did we answer Debbie's question, Jackie, about legal capacity while I was?
Yes, we just
Okay.
answered that question.
Okay, I thought so. I just want to make sure. So.
Oh, I have one that came in through the private. The question is, Michael, thank you for the presentation. And I'm also in a situation where I do see my parent having an early stage diagnosis. Do you have any tips in terms of how I can encourage my parent to have a conversation with an elder law attorney, how can we get the ball rolling?
It's one of those things that for some people it's really easy. It's like some people with Alzheimer's dementia, like my dad, were really easygoing and wanting to be helpful. But a lot of people are not as much. Like they're in sort of denial. They don't want to talk about their finances. They're just maybe uncomfortable. They don't want to share information. So until the person's really ready, it's difficult to do a lot of things for them. I mean, sometimes clients just say, "Hey, we'll start out with a healthcare proxy power of attorney, and then we'll work towards doing a trust at a later point." But I think it's one of those things that you need the person to be comfortable about talking about this and acknowledging they have it. Because again, I think that's a big hurdle for a lot of people is that they have diagnosis, they don't feel like they have Alzheimer's dementia,
Mhm.
but and they're afraid to admit it, and they don't want to do anything that they think sort of locks the money up in place or locks the money up that they can't touch it. So they, and unfortunately, as any part of the asset protection process, you do have to trust somebody else, whether it's a spouse, a child, another loved one. You do need to sort of empower someone else to help you. And for a lot of people, that's really scary. But it's one of those things that I think it's an important conversation to have. And again, you don't have to throw it upon them one day saying, we must do this and get everything done in one day in one meeting. But start the process slow, make sure they're comfortable with the idea, bring it up to them multiple times perhaps. And just whenever they're ready to do it is when it'll happen.
Thank you so much, Michael. Do we have any other questions? Any other comments? So Roseanne asked, how can I reach out to Michael? So again, we included Michael's information in the chat. And Roseanne, I will also include Michael's contact information that we shared in the chat. I'll make sure to include that in our follow-up email. You can go ahead and share it one more time here for us so that we do have it. Of course. Okay. Deanna says, thanks for all the information, very helpful, of course. Well, if there aren't any additional questions, again, on behalf of the Alzheimer's Association, we want to thank you again, Michael, for your continued support. Thank you for agreeing to be part of the Ask the Expert series and providing your insight. I want to mention to folks that Michael regularly gives presentations for us, so we're always extremely grateful for your continued dedication and support of our caregivers and of our community who has received a diagnosis of Alzheimer's and other types of dementia. So if there aren't any questions, I will, again, I'm going to share my screen one last time to remind folks that we do have our following Ask the Expert program, which will be next week. This is an in-person program in our office. We're right across the street from Grand Central on the east side on 42nd Street. So Dasha Keeper will present Your Brain on Caregiving. So it will be a very intimate and a very insightful conversation where we're going to talk about the cognitive and emotional challenges a caregiver might face. We hope to see you there, and I'll make sure to have this follow-up information. Again, this is for next Wednesday, November 6th from 1 to 2 p.m. If you are here in New York City, we would be super happy to have you join us. So, well, thank you everyone for joining us today. Again, if you have any questions, please feel free to reach out to our 24/7 helpline. The number is 800-272-3900. All right. Thank you, everyone. Have a wonderful day.
All right, thanks, everybody. Take care.
Thank you,
Okay.
everyone.
Bye,
Thank you,
everyone.